Mr. Chairman, I did prepare an 8-page statement. There are copies of it over there. Do any of you need copies at this point? Okay. And you had asked me to take a look at what legislative actions you might take as a result of the situation with Harrisburg's Incinerator Debt, which is what this statement is addressed to. So it goes through a lot of detail, but I'd propose that I would just give in summary fashion the 5 proposals that are in here and then answer your questions, if that's okay. Okay, thank you. I'm making these recommendations based on my experience as receiver for the city and also for being a bond lawyer for over 30 years in Pennsylvania and working on financings for all sizes of local governments in Pennsylvania. So I really have 5 proposals for your consideration, for the General Assembly's consideration. The first is to amend the Local Government Unit Debt Act to improve the Debt Act process, including the review of proposed self-liquidating debt. When debt's entered into in Pennsylvania, it's a 2-step process that's a lot like buying a house. You first have the bond sale, which is like the agreement of sale when you agree to buy a house from somebody, and then you don't close it for about 30 days later. So when you're buying a house, you have to get the house insurance and things like that, as you know. And on a bond issue, there are certain things that happen between the bonds being sold, marketed to the public and sold, and the time you close. The way the Debt Act works is DCED doesn't even know that the local government is considering a bond issue or a guarantee until, in most cases, until the bond sale's already occurred. So in this case, the city enacts an ordinance for a guarantee, and then subsequently that guarantee and the debt statement and other things are filed with DCED. So, and that's different from other states. North Carolina and New Jersey, for example, they know when a local government's interested in going into the market, and they ask them some hard questions before they do. So, what I'm proposing as the first proposal is to have a 2-step process under the Debt Act, to have another process before the local government goes into the market. And this wouldn't be on the normal deal where you're just building something that's within your debt limit and so forth. But there are 6 items that I would suggest that DCD be informed of by the local government before debt's issued. One is the local government certifying that its audited financial statements are up to date. I think in a lot of the problems you see around Pennsylvania with local governments, their audits are long overdue, which is partly the case in Harrisburg. But that's a sign that there are real problems. And I think if a local government doesn't have up-to-date audited financial statements, the DCED should be empowered under the Debt Act to tell them they can't go forward until they get their books done. The second recommendation is similar to that. There are requirements on publicly offered bonds under rules of the Securities and Exchange Commission that the local government, for bond issues that are already outstanding, provide information to the market, annual financial information, and also notices of extraordinary events like payment defaults on bonds and so forth. And I'd also recommend that the local government have to prove to DCED that they're up to date on their secondary market disclosures under the federal regulations before they can issue debt again. And that's another sort of sounding bell that something could be wrong. If a government's behind in those disclosures to the secondary market, it usually means that there's some problems or that they're extremely sloppy. So the other 4 items that could be run by DCED first before the bond sale would include 2 related to self-liquidating debt. So if you want to do self-liquidating debt, I think the time for the analysis is before the bonds go into the market. And once, as I said before, once the bonds are sold in the market and before you get to closing, there's a great amount of pressure on DCED to approve a debt filing because they know if they don't approve it, and then the underwriter has to go back to the people who wanted to buy the bonds and tell them, forget it, we don't have the bonds, that negatively affects the local government the next time they want to go into the market, either for that same project or for another project. It's just a very bad thing. So it puts a lot of pressure on the lawyer at DCED who's reviewing these things to come up with a yes answer. And so I think in the case of self-liquidating debt, if a local government wants to have self-liquidating debt, that DCED should, that they should file with DCED whatever reports and so forth that show that it's self-liquidating before the bonds go into the market. Also, if a local government has self-liquidating debt outstanding, and this is sort of the look back 8110B test, and they want to do a new bond issue, that they have to show DCED that in fact their existing self-liquidating debt continues to be self-liquidating. And if DCED is not satisfied, they can prevent the local government from going forward. Two other items I'd suggest. One is if a local government's doing a refunding that does not have present value savings, they're doing a refunding for some other reason, such as those scoop and toss refundings that Steve Goldfield testified to you about on the first day, where you're just trying to push debt out into the future. That any sort of refunding like that should have to go to DCED first. And there should be an explanation to DCED about why that sort of non-economic refunding is in the best financial interest of the local government, in the long-term best financial interest. So you may have DCED react and say, fine, you can do this once and then get your house in order in 2 years. But this repeated series of scoop and toss refundings, which you saw in Harrisburg, I think DCED would say no at some point to those types of financings. The last recommendation is that if there's a financing that involves over 10% of the proceeds going for working capital, as opposed to bricks and mortar on the project, that the local government have to show DCED that it's in the long-term best financial interest of the local government to have that much working capital in a bond issue. So what I'd suggest is a preliminary process where those items, if they exist in that bond issue, proposed bond issue, would have to be run by DCED first, and then DCED could say fine or not fine or whatever. And then if they say fine, the local government can go ahead and do the process that they do now under the Debt Act and issue the debt, price the bonds, file with DCED, and get the debt approved. I'd also recommend in that regard that local governments be prohibited under the Debt Act from collecting guarantee fees. I think there's been too much games playing with that and moving money around. That if a local government wants to guarantee the debt of its authority, it should do so that the authority can have lower interest costs on the debt. So the bonds will bear interest at a lower rate because of the guarantee. It shouldn't be done to be transferring money from the bond issue or from the authority over to the local government. So that's my first recommendation is those amendments to the Debt Act. The second recommendation is to amend the Debt Act and the Municipality Authorities Act to prohibit local governments and authorities from entering into any new interest rate swap agreements. There have been a number of reports regarding swaps in Pennsylvania. One is the forensic report for Harrisburg, but also Auditor General Jack Wagner issued a report in 2009, which talked about the Bethlehem Area School District and other situations around the state. And the Auditor General recommended prohibiting swaps going forward. There was also a study by the Pennsylvania Budget and Policy Center, which is a nonprofit, in January of this year that analyzed the swaps entered into by the City of Philadelphia and the Philadelphia School District. And that study estimated that the combined losses of the city and the school district through last year on their swap transactions was $331 million. And they still have exposure for losses of up to $240 million. And the Philadelphia City Council held a hearing on October 23rd of this year, just a few weeks ago, to look into what happened with these swaps in the city of Philadelphia. And they took testimony from a lot of the professionals and also from the Auditor General. But I think when you look at these studies, my conclusion, and from having done interest rate swaps and been involved with them, is that that the Act 23 of 2003, which amended the Debt Act to allow swaps, should be reversed. I think it's been a failed experiment. It's not that there haven't been good swaps, and maybe even most swaps are good. But first of all, the repercussions when a swap goes bad are multi-million-dollar problems. And when you think about it, what else would you authorize local governments to do where there might be a 1 in 10 chance or even a 1 in 100 chance that they're going to have a multi-million-dollar problem as a result of what they're entering into? The other thing I'd say about swaps in local governments is they're incompatible with the way public officials and elected officials operate. It's very difficult if you have to terminate a swap, right? And when the Great Recession hit, a lot of local governments had entered into what are called swaptions, which is a specific type of swap. But there's one county, which is a fairly strong county in the state, that had a swaption, and they had like a 5-year window to decide whether to get out of the swap. And when you get out of a swap early, you have to pay a termination fee, and it's based on lots of calculations of present value of flows of money. But that county in particular, in 5 years ago, they could have gotten out of this swaption for $4 million. And they had the money. It's a fairly wealthy county, but they politically simply couldn't, the county council, get themselves to vote to send $4 million off to some bank in New York to get out of a swap that they probably shouldn't have gotten into in the first place. And so they didn't do anything, right? They sort of waited to see if rates would go up instead of down. And then you're into gambling, right? Which isn't good. But, rates kept going down, which was against their financial interests. And so finally they had to terminate the swap because they got at the end of this window this year, and they ended up paying a $24 million termination payment. Right? And I'm not saying that to criticize these officials, but just to say it's not compatible with how you all as elected officials have to operate in the public bubble you operate in to make decisions like that. A treasurer of a corporation, of a private corporation, they can say, okay, we have to bite the bullet and take the loss. We did something that we shouldn't have done. But it's very hard for public officials, and you just get into worse and worse situations if the market continues to go against you. So I think these instruments are not necessary. Public finance was around a long time before 2003, and local governments got to do their financings, and they should not be given this power anymore. It's pretty much like a game of Russian roulette, where every once in a while the bullet's going to go off and there's a bad situation. So that's my second recommendation. The third one is to amend the Debt Act to include criminal penalties for knowingly participating in an ultra-vires act, an act that's beyond the power of the local government, or for filing a materially false certification with DCED, or for aiding and abetting any such act or filing. The securities laws operate under the assumption that people involved in these transactions are going to act fairly and in the best interests of both the issuer and the purchasers of the debt. And I think the Debt Act in large part is operating that way too. I mean, it puts a lot of trust in the professionals in terms of what they're doing. And I think when I look at transactions that have happened around the state for school districts and local governments, that there needs to be some fear of the law put into this statute to prevent people from going up to the line or over the line on some of these transactions. So even though there is another existing statute that could be utilized in the Harrisburg situation, where making a false statement under oath or filing a false certification intending to mislead a public servant and performing his official function is a crime, I think having a specific criminal provision in the Debt Act itself would prevent a lot of these problems, or at least make people think a couple times about it. The fourth recommendation is that the General Assembly should pass no further extensions of the bankruptcy prohibition. As you know, in June of 2011, the General Assembly prohibited third-class cities from filing for bankruptcy for a one-year period, which ran through June 30 of this year. And then in June of this year, the General Assembly extended that prohibition through the end of November this month. For municipalities that are in distress, as the Distressed Municipalities Act has been amended, it requires the approval of the Secretary of DCED before they can file for Chapter 9 bankruptcy. And in particular, with respect to Harrisburg, which is under Chapter 7 of the Distressed Municipalities Act, Act 47, they can't file without the receiver taking them into bankruptcy. So with respect to Harrisburg in particular, I don't think that the General Assembly needs to be concerned about there being any frivolous bankruptcy filing for Harrisburg, because it'll require both the receiver and the Secretary of DCED to approve it. And so I think that these bankruptcy prohibitions only help the creditors that the receiver's trying to deal with. I think General Lynch is doing a very good job as receiver. I think he's got difficult negotiations he has to do, and he did ask the General Assembly in June not to extend this thing. It was extended, but it shouldn't be extended again. And I know that that won't happen this month, but when you come back in session next year, it should not be resurrected. I think that should just be put aside and let things play out as they will, because the threat of bankruptcy, although you want to avoid bankruptcy, the threat of bankruptcy is crucial to the negotiations that have to happen to resolve the debt problem. The last recommendation is that the General Assembly should ask the State Attorney General and the United States Attorney to conduct a criminal investigation of the Harrisburg Incinerator financings, or the General Assembly should pass an act for the creation of a special prosecutor to conduct such an investigation. I think that, well, when I was receiver, it struck home to me because I talked to lots of people in the city and dealt with the city administration and all of their challenges and stuff. But the effect of this debt that was put in place in Harrisburg for the incinerator, it's not just a story about an incinerator that was a bad investment. It's had an effect on everything that happens in the city because it completely messes up the financings of the city. And it has the city then doing ill-advised things that they may not have done otherwise in areas unrelated to that debt because of the overwhelming burden of this debt on the city's finances. And so it affects everything. It affects water service, sewer service, police service, fire service, trash collection, economic development, parks and recreation. All these departments get cut back to the bone because of this debt. And so, the lives that are lived by the people in the city have been dramatically, negatively affected by the problem that we're talking about today. And there was an identified group of people who put this debt together, many of whom you've heard from last month and today. And I believe that this debt was simply not self-liquidating. I think the 8110D certificate, I don't agree with the analysis that there was one project. I remember before I became receiver, around the time I was nominated, I went over to the authority, the Harrisburg Authority, and asked them to put all the bond documents on the table for me. And I'm an old bond lawyer, so I can go through 10 feet of bond documents in an afternoon, but looking for specific stuff. And I did look at that ordinance that was enacted in 2007 for the city guarantee of the C and D notes. And I was reading the project description, and it went on and on and on. I said, why? Why is this project description so long? And then I get to the end, and they define it all as one project. Well, that's an absurd interpretation of the Debt Act, in my opinion. You might as well not have debt limits, if that's what you're saying, because that means as long as you think that the next debt that you're going to issue is going to solve the problem, you can issue that debt. And if that doesn't work, then issue more debt and think that that's going to solve the problem. And meanwhile, you've got all these numbers here. I agree with Senator Eichelberger, what you said earlier, Senator. When you read that language in 8110B, that's a look-back test. Were there changes in circumstances that have occurred since the last time you issued debt that would make you believe that the debt that's outstanding is not self-liquidating? How can you look at those numbers on that chart and not come to the conclusion in 2007 that there was a change in circumstances? Also, defining a project as going from 1993 to 2007, it's just illogical. There were multiple contractors, multiple boards, multiple administrations, professionals. I mean, time had gone on. Things had changed. There was before Barlow, there was after Barlow, and saying all that is one project. When I was reading that transcript, that ordinance in November of last year, I mean, I was just sort of dumbfounded. And I said to myself, this, I know why this is being done. This is being done so you can put it in front of DCED and have Bernadette Berrettini say it's one project and, put the stamp on it, right? But the purpose of the Debt Act, but the main purpose of the Debt Act is to avoid situations in which so much debt is incurred that the taxpayers can't pay it. That's the reason that act is there. And every little provision in the 30 pages of that act are geared to that one purpose. The lawyers involved should know that, right? And the financial advisors. I mean, all these people deal with the Debt Act all the time. They know that's the purpose. And yet to come up with, in my view, twisted interpretation that somehow you can have one project and you can run as much debt into that one project as you want without ever reckoning with the fact of whether it's really self-liquidating or not is against the basic purpose of the Debt Act. So I've beaten that one to death. But I think this needs to be looked at by a criminal prosecutor. I'm not a criminal lawyer. When I was a receiver, I was asked frequently by people when I was out talking with city folks and others about, what do you think of the criminal aspects of this? And I would say that's not my job, which is what General Lynch is saying now. It's really not the receiver's job. But I got to the point where this thing was so bad. I mean, it stunk like a kettle of rotten fish. I mean, and that goes through all the testimony you've heard for the 2 days of your hearing. Nothing fits together. And you need a prosecutor, a criminal prosecutor, to get all the emails, all the letters, everything. Take a look at it. Maybe there was no criminal activity. I don't know. But there certainly was, and as I said publicly before, there certainly was disdain for the law. I mean, there wasn't a sense that, these laws are here for a purpose. The General Assembly passed them for a purpose. We've got to give some respect to what the intent of these laws are, not just to drive through whatever you can drive through with whatever interpretation you want of that statute. And I would encourage the General Assembly to ask the U.S. Attorney and ask the new Attorney General to look at this, and if there's no reaction there, to consider passing a statute appointing a special prosecutor to take a look at the debt situation in Harrisburg. And that's my testimony. Thank you.
Thank you, Mr. Unkovic. Senator Fulmer?
Yes, I actually answered my first question I had for you, but my second question would have been this. It would appear the city of Harrisburg hid a structural deficit for many years by borrowing and or dipping into other funds. Is that true or false?
I think that's right. And
well, could you give us some background on
sure,
how this was done?
That would require a forensic report of its own. So a lot of what I discovered as receiver was sort of anecdotal and some here and some there. But you've heard a lot of that in the testimony that you've heard in 2 days too. So for example, when Steve Goldfield testified the first day, he testified about the bond guarantees and how that money basically went over to the city when they would guarantee. He testified as to these scoop and toss refundings where they push a couple years worth of debt service out of the next 2 years and off into the future. When Bruce Barnes testified today, he's saying that they were entering into some of these transactions to obtain current monies, right? Other things I found when I was receiver was the overcharging of utility charges that the city runs the authority. Actually, the city for the authority operates the water system and the sewer system, and then for example the sewer system serves I think 6 or 7 suburban municipalities as well as the city, and the charges that were imposed by the city on suburban residents and on city residents for the administrative costs of the city running the sewer system were well in excess of the actual costs. The actual costs were less than $1 million, and the amount allocated that they wanted covered allocable to administrative costs was $7 million from suburban residents and city residents. So all that money would get overcharged and then moved over into the general fund and run the city. So in effect, the suburban municipalities were helping to run the general fund of the city. Now, some of these things I think are caused by the fact that the finances for cities generally in the state are problematic because of the union contracts, the inability to control the labor costs, the pension costs. I mean, there are lots of reasons for that. In Harrisburg, it was all exacerbated by this debt and by lots of other actions. So it in some ways, you want to excuse what happened because these mayors and city councils are in tough positions. On the other hand, in Harrisburg, it seems that they did it all. I mean, all the options of how to move money around and create money and take money from here and put it there were done. So, Steve Goldfield testified the first day that it's a lot like paying your rent on a credit card, right? Which it was. But to expand that analogy a little bit, it's like paying the rent on your credit card, and then you keep moving into more and more expensive apartments, right, every year. And so, at some point the whole thing crashes, and that's basically what happened here. So, does that answer your question?
Yeah,
Senator?
yes, it did. Thank you for that background. Mr. Unkovic, you had many interactions with the citizens of Harrisburg when you were receiver. Is there anything you would want to say now to the citizens of Harrisburg?
Yes, I feel bad for them, right? I show up becoming receiver and talking to all the people in the city, and they really have not been treated well over the years by their officials and by the public finance industry. But what I would like to say to them, and I know because of these problems, they're a very cynical bunch, right? I mean, they don't trust anybody, and because of the experience of them being abused over the years by people that have had power over them, and by people that have been hired by people that have had power over them. And what I would hope that they would do was, at this point, to get less cynical. I think, in my mind, that we've reached a tipping point here, and that there really is light at the end of the tunnel. I think General Lynch is doing a very good job as receiver. I think the plan that he's following is the plan that the Commonwealth Court approved back in February. And I think it's a good plan. I know there are a lot of people in the city that just want to file for bankruptcy and think that's the answer, but it's very important that there be an effort to get contributions from people who should contribute to the solution here, including the creditors, significant contributions. And I think that the people of the city have to be have to give the receiver some slack at this point. I think he's doing the right things. He's got a hard job. I think he'll do everything he can to get there, and I think he will. That doesn't mean they shouldn't ask questions. That doesn't mean they shouldn't push, as they always do. But they should be less cynical. I mean, there's all of you, right? You three senators who have, courageously decided to hold these hearings, which you did not have to do. Because you, I think, also were outraged by what's happened to the people of this city. And, I commend you for that. And I ask, the citizens in Harrisburg to recognize that and to thank you when they see you for doing these hearings. And these hearings have been very important because they've gotten stuff out that hasn't been gotten out before. And they've had people testifying who haven't publicly testified as to what they did in these situations. What needs to happen? There needs to be more happening. And my own opinion is, just based on my conversations and my experiences as receiver, that it's probably a long shot that the U.S. Attorney is going to handle this. I don't think they will. I think it really comes down to the State Attorney General's office investigating the situation. And what could be more important for an Attorney General of the state to do than to investigate how the financial condition of the state capitol got ruined, right? It really calls out, and I hope the new Attorney General, when she comes in, looks at this, and she may find no criminal violation. But certainly it needs to be looked at. Things were not done the right way here. Things were done in ways that are just hard to explain. They're even hard to explain to the people who've testified to you because they point fingers at each other. It wasn't me, it was him, it was her. And I think in part that's because they're not comfortable with what happened. And some of them maybe should be a lot more uncomfortable than others, that there will be an investigation of this, and I hope there will be.
One last question. What have these hearings gotten out that hasn't been gotten out before or should have been previously aired?
I think when you look at what the forensic audit that was done was really an excellent report, I think. And it may not have been accurate in all of its facts, but that's because they couldn't get all the facts. They didn't have subpoena power and so forth. So I think, that it was courageous of the Harrisburg Authority to commission that report, and I think the forensic people did a great job. But even when you read it, it's like half a report. There are lots of things that you ask yourself when you read that thing. And I think that's what you've done today. I think, and on October 4th, I think you've gotten people who are involved in this to testify and say things. And even the fact that they say they don't remember things, that might be incredible that they don't remember. I think it's good to get that on the record. I think it's good to get as much as you can. And the answer is we don't really know what else there is out there, or what really went into these decisions. Whether there was really, some sort of intentional violation of the law until you get all the facts out. And that's not going to happen in this room. As important as what you've done is, it's only going to happen with an experienced prosecutor looking at what happened here.
Thank you.
Thank you, Mr. Chairman, and thank you, Attorney Unkovic. I'm grateful for your candor and your professional presentation of important information today. For me, as the minority chair of local government, I actually opposed the prohibition on bankruptcy on the floor of the Senate, and was a little bit upset about the rewriting of a new chapter of 47, but that's another issue that I think is parallel to this one. I don't know that you can comment on this, but I'm going to throw it out there and ask you to consider. I think that this is an anomaly of a situation because of the scale of the impact on this small city, but I'm not sure that it's the only circumstance throughout this Commonwealth that threatens the fiscal health of a third-class city anywhere in the state. And I don't know whether or not you can speak to this. I think Mr. Losty mentioned there's 700 swaps out there. If there was a gyration in the market, I'm sure that some of our cities or our municipal authorities could be posing a threat to their circumstances as well. I don't know if you want to comment on that, but I do have a specific question too, relating to your comments about whether or not we should even have the self-liquidating debt exclusion in Laguda, and the issue of guarantees and the proliferation. I'm not sure you can comment about the extent to which you have these third-party guarantees of counties or municipalities behind municipal debt, and should that not be a trigger point for additional, more thorough scrutiny on the part of the DCED with regard to municipal finance and debt issuance? That's a lot of stuff.
No, I have to write a note or I'll forget what point one is. Let me answer the second one first. I think guarantees are good in a lot of situations. Where you have your typical township that also has a water system, it's real hard to sell a township's water bonds without the municipality behind it, because the system may not be large enough for an investor to be truly comfortable that in all situations that the system's going to carry itself. But it may be a system that has carried itself for 40 years and is well run. And I think townships like that should have the opportunity to guarantee their authorities' bonds so they can get sold. So I think there are most situations in the Commonwealth, I think, are positive ones like that. So I don't think it's a good idea to say that there shouldn't be self-liquidating debt. I think in many cases, in most cases, it's a very good idea. So, your question generally about the finances of cities in Pennsylvania and if you do read the original recovery plan, which I filed with the court in February, and which they approved in early March, there's a whole section that talks about financially, the challenges of the finances of cities in Pennsylvania, and I specifically put that in the report because in some ways Harrisburg's unique because of this disaster with the incinerator, but in some ways it's emblematic of the problems of all the cities in Pennsylvania. I mean, it's not unusual that there are overcharges on utilities and the money goes into the general fund. For a lot of cities, it's how they keep going, right? So you're going to find that in different places around the state. And that's not my charge here is to advise you on that. But I mean, there are large issues which I know you are going to be dealing with pensions and labor, public union contracts and so forth that just have to be dealt with. And taxing power of cities. I mean, you've got a city here which has half the land is tax exempt. and you've got a third of the population that's below the poverty line. I mean, it's a very poor city. I mean, there was testimony here about self-liquidating debt where, as long as you have a rate covenant, the debt's self-liquidating. I mean, that seems like the ultimate argument that I was hearing here today, but that's an absurd argument in Harrisburg. You can only charge these people so much, and they only have so much money. And, there have to be other ways to address these big problems to solve them for all the cities.
I appreciate that.
Yeah.
I guess you already commented on the forensic audit, and it had been challenged by several of our testifiers, but your assessment is of high regard here.
Well, thank you. And I don't say that there aren't some mistakes in it. And I'm sure the people who wrote it would say they might have gotten some of this wrong because they didn't have all the facts.
Mm-hmm.
They got as many as they could, and they did the best job they did. And these people worked extremely hard. When I was receiver, I was on the horn with them every week. When is that report coming out? Starting in early December. And, it finally came out in January. And they worked all through Christmas weekend, New Year's weekend. I mean, they worked 20-hour days to get that report done. So, yeah, there might be some things in it that are wrong, factually wrong. There might be some conclusions that people would argue with. But I think on the whole, it hits the nail on the head on what happened here.
Thank you. My last point, which is really related to your prior testimony and your written testimony, and I'm very grateful for that because I started this process by announcing that we were not prosecutors, that we were really just trying to find out whether there were regulatory or legislative flaws or weaknesses, and I think that your recommendations will inform the committee's future deliberations about legislative action. But I do think that this issue of fiscal health of our communities, in particular here, if we incent behavior that allows local government officials to essentially find an easier way to just get the books balanced at the end of one year versus another, I think that we're doing a disservice if we don't correct that kind of incentive. So thank you very much.
I agree with that.
One point that I've been trying to get to today was getting an explanation, at least in theory and maybe factually, how this waterfall of payments and how this all interplays so that we see the city and the county, which get guarantee fees, to take a risk and back up payments that were missed by the authority. And then when that happens, there's refinancing done, there's a side agreement, and the burden then gets larger in the new borrowing to pay for another guarantee and then to pay for the old money that was paid out under the guarantee agreement, the old guarantee agreement. Is that something that you've seen in your 30 plus years of work in doing bond counsel, that kind of arrangement where we have this continual increase of debt obligation?
No, I haven't. And I mean, one of the things that tells you that this debt was never self-liquidating is just looking at the uses of the money. I mean, if you're constantly issuing, as Steve Goldfield testified to this in the first day, when I went through those documents, this was before there was a forensic audit or anything, I mean, it struck me immediately. You look at the sources and uses of fund for every one of these financings, and it is like running up your credit card. It's just working capital. I'll pay you back for these debt service payments you made the last 2 years. Here's some money for your debt service payments the next 2 years. I mean, you don't do that for an operation that's working. You do that for an operation that's not working. So to have all that going on and all these financings, and then to be filing certificates with the state that says this stuff is self-liquidating, I mean, it struck me right away that wasn't right.
And Senator Blake had talked about guarantees. How about guarantee fees? In your experience, how much of that have you seen?
I've never seen any outside of Harrisburg. And I've probably done 800 bond issues in my career, like 25 or 30 a year, and most of them under the Debt Act, for all sizes of local governments all across the state. Yeah, I don't see that. I mean, because it doesn't make any sense. When you get a guarantee fee, let's say your guarantee fee's $1 million, right? That money doesn't come out of nowhere. You have to issue another $1 million of bonds to pay that $1 million fee at closing, right? So now, on top of the problem you've already got, this problem of how you get this incinerator to work, you've got the guarantors taking money out, not even taking money out, just issuing more debt, which solves everything at Harrisburg, right? You issue more debt, and then that debt is amortized over 20 years, right, at 5%. And so it doesn't make sense to take guarantee fees out. And, there was some testimony today, I think it might have been Bruce Barnes, who said, how did they calculate, maybe it was somebody else who said, how did they calculate what that county guarantee fee was going to be? And they said, well, they sort of present valued the debt service savings that the authority would get by virtue of the guarantee. Well, then, you're not helping the authority, right? You're helping them sell the bonds, because otherwise you probably couldn't sell the bonds. But you're sucking out the savings that the authority's going to get by using the county's AA rating or whatever it is. So, it's lots of absurdities.
Well, and the follow-up question to that would have been, which I should have asked, or maybe somebody should have, and I did ask it the first day of hearings, is you must reach a breaking point where you do get somewhat of a discount, but sooner or later you eat up that discount with all these additional fees. So
You mean the discount from what? I'm sorry.
you get a better rate, so you save a little bit of money. But saving a little bit of money, maybe $1 million, you would save more than $1 million. But if the guarantee fee is $4 million, you're out $3 million.
Right. The best approach is not to have a guarantee fee and just do it because the government wants to help the authority. I mean, the only reason you set up an authority is to put what are sort of project operations separate from your general fund budget. So you can run an incinerator or run a water system or whatever and put it in an authority so they can focus on run it like a business, right? It doesn't make any sense to do that and then suck money out of that business back into the city government.
My last recurring question that I would ask you is, do you see an ethical obligation, particularly for attorneys, but for anybody, any professional that's involved or has been involved in this project, to bring forth significant red flags to the extent that stop the project or hold things up, do a new analysis, do something, when they have knowledge of all the facts that we've just talked about, and they continue to say, well, it's compartmentalized, I was told to do this, this is what I did, it checked out, I'm done with my obligation to my client?
The short answer is yes. When you read Judge Jones's opinion in the CIT litigation, and I know he held in favor of CIT, right, against the authority, but you read the last couple paragraphs of that opinion, and he addressed that specifically. He said, this is just a terrible set of facts where a lot of smart people with a lot of experience were working on these financings, and they never said, don't do this, don't double down, don't do this next thing, cut your losses, this has been a disaster, cut your losses, that's it. And Judge Jones felt that way. Now, he said these contracts are binding, so I'm going to have to rule in favor of CIT. But I think anybody that looks at that wonders why no one did stand up and say, don't do this. And then sometimes, it's very rare, and Steve Goldfield said this when he testified, and it's very rare in my career too, where sometimes you actually don't do something because it's not right? And you walk away from what otherwise would be a fee. And, you don't like to do that or you don't eat, but at some point you get situations that are bad, and this is the worst set of financings I've ever seen. And, if you don't raise the red flag here, I don't know, where you do. So.
Senator Fulmer.
My last question is and thought of this while you were talking. What value, if any, would there be to appropriating some state money to complete or otherwise follow up on the forensic audit, but with subpoena power?
I think it would be good to get the whole story of what happened. Now, for your purposes, you have to consider legislation you might want, like some of the things that I suggested here today. Whether you need more facts to do that, I don't know. I think a lot of the facts you've got at this point, at the level of coming up with legislation to fix the Debt Act and so forth. In terms of whether there were criminal acts here, I think you need a lot more. And I don't know if that comes from you. It probably should come from from a full-time prosecutor.
Thank you.
Senator Blake has some closing comments. Do you want to address anything to Mr.
No,
Unkovic?
no, thank you very much.
Okay.
Yeah, we want to
Bill,
thank you
something?
for
Thank you.
everything. Very
Excellent.
much.
Just a quick comment. I really, well, just I want to thank the chairman for his leadership in this matter. These are difficult and complex issues to undertake, but I would be remiss if I didn't extend thanks to my staff, Luke Muron here, and my chief of staff, and my legislative director, as well as Lee Durr from Senator Eichelberger's office for the research that was done here. I also, I think it's important to go on the record. I think it's important for me to just say this. I've had some considerable dialogue with Senator-elect Rob Teplitz, who will be representing Harrisburg come January. He and I have communicated quite often on this matter, and I know that he'll want, the moment he takes office in January, to hopefully play a constructive role in the legislative process that unfolds in the wake of these hearings, and I thought it would be important for me to say so. And again, just want to thank the chairman. Thank you.
Thank you, and this has been a joint effort with Senator Blake and myself, and really Mike Fulmer, who has been deeply involved in this issue, and he represents part of Dauphin County. So the staff has been, I think, outstanding. This has been a lot of work for everybody, and I appreciate that. And I need to read a statement for the public here before we adjourn, for the record, that says that I would mention that for the information of the public, that the legislative record of these proceedings shall consist of the stenographer's transcripts of the hearings, plus documents referenced in those transcripts, testimony submitted to the committee, and a copy of the forensic investigative report without exhibits, commissioned by the Harrisburg Authority, which shall be attached to the transcript. The record will be made available to the public as soon as the transcript is ready, by placement of a copy by the Secretary of the Senate in the Senate Library and on the committee's website as indicated on the agenda. So, thank you all for attending. We're adjourned.